set up an initial consultation with one of the attorneys in our office. That is a complimentary consultation. We usually set them up for about 2 hours. So again, it's complimentary. It doesn't cost you anything to come in and talk to us. But we set them up for 2 hours because we like to really get as much information as possible and really see what we can do to help. And then the other piece of information that you'll get is actually our top 9 estate planning myths that kind of tells you what the myth is and then what the actual kind of reality is for most people. So that's a really helpful sort of cheat sheet, I think, for a lot of people, because a lot of these are, we hear probably many times a day. I lost count, but these are very, very common myths. And then if you enjoy this webinar, our topic next week is actually protecting the family and things that you can include in your estate plan to sort of protect people from themselves, potentially if it's a responsibility concern or some other concern, or protect people from others too. And it's a pretty fitting topic given that it's Valentine's Day, right? Protecting those that you love. So just as a reminder, that's next week. So, all right, to get started and kind of hit the initial topic anyway, get that out of the way right away. Do I inherit my parents' debt when they pass away, or do my kids inherit my debt when I pass away? The answer to that in Wisconsin anyway is no. So there are no laws in Wisconsin that say a child is responsible for their parents' debt just because of being their child. So there are laws in some states called filial responsibility laws, which are essentially saying that, if your parent goes into long-term care, you may be responsible for those, those costs as the child, or you may have to pay for it. You may be responsible for their debt when they pass away that are associated with things like that. And that, my understanding is even in those states, those laws are not often enforced, but they exist. In Wisconsin, thankfully, we don't even have to worry about whether or not they'll be enforced because they don't exist in the state. So you do not, in Wisconsin, inherit a parent's debt when they pass away. So you don't have to worry from the other side of that either, passing on that debt to your kids. Now, know that that debt will be dealt with through someone's estate administration, right? And there are certain things that you still have to do as like a personal representative or as a trustee of a trust after someone passes away to make sure that that debt is dealt with properly. But the beneficiaries themselves don't inherit that debt. It's not like kind of the old like debtor's prisons, right? That is what that kind of law always reminds me of. So what I mean by the personal representative and the trustee still has to deal with certain things is there's certain reporting things they have to do. They have to give notice to creditors, right? As in the administration of the estate. And that usually is a set period of time, depending on whether you're using a trust or a will, that time is going to vary a little bit. But it's usually 90 days for someone going through probate, right? And then it is 120 days roughly for someone using a trust. And that is so that people, public notice is given where creditors have a chance to come forward. The law says we want to give these people a fair opportunity to make a claim against the estate, so give them ample time. And you do have to give direct notice to creditors that you know about. So that's where the personal representative in someone's will is going to have to send notice to these companies that, yep, okay, this person's passed away. I understand that there's a debt. You have this time period to come forward, right, and actually file your claim with the estate. So where this comes up quite a bit as actually making direct notice, right, is probably someone's final hospital bill. I think is maybe one of the most common because you kind of know about that, right? You're anticipating that bill coming in. Maybe not the size of the bill, but you're anticipating it nonetheless. Whereas the difference might be, oh, I forgot about that credit card, right? Or I didn't know they had that credit card debt, right? So that's a little different. But you still have to give public notice. But again, that's more the responsibility of the person handling the estate, meaning the personal representative or the trustee. It's not the responsibility of the individual children. And the personal representative or the trustee, the person in charge of the estate, may not even be a child, right? It might be a professional. It might be a family friend. All of those people it doesn't matter who they are, they can be appointed in that role if that's what that person wanted. So it's not tied to the family in any way. So the reason you have to do that is if there's enough money in the estate to pay off those creditors, they still kind of have first dibs on it. No differently than somebody going through a bankruptcy, right? You have to pay the creditors first before you start giving the money out to all the beneficiaries. If you just give all the money out to all the beneficiaries as a personal representative without notifying the creditors, the personal representative may have some liability there. So it's important to do that the right way. So again, that's on the estate side of it, though. It's not on the family side. You're not like inheriting that. If there's not enough money in the estate to pay off all the creditors, that's when you would have, again, very similar to a bankruptcy. They can take what they can get in order of their priority of their debt, but they can't then come after the family. They can't come after the personal representative personally, as long as, you know, all of that's been followed properly. So it's really not as scary as it sounds in that sense. I mean, obviously we all want our kids to inherit something from us, but it's better that those steps are followed than like the personal representative, who may be one of the kids, being responsible for not following the proper steps. But you do not have to worry about the beneficiaries themselves inheriting that debt. So hopefully that allayed a lot of concerns. I know that's a big concern for people. So just know that that may not be true in every state. There are states with those filial responsibility laws, but my understanding is that they're very rarely enforced, probably because there'd be some pretty big arguments against whether or not that's even, you know, constitutional. So, you know, that's just something to keep in mind, but I wouldn't worry too much about it, especially not here in Wisconsin. So what I'll kind of do with the other myths is run through some of the biggest ones that I can, you know, that we come across a lot. So I think probably one of the biggest myths that we run into would be whether or not someone is going to go through probate with their estate. They often come in with a will or want to have a will drafted because they want to avoid probate. That is unfortunately not how wills work. Wills specifically direct assets that are in probate. So they don't force things to go through probate, but they only control probate assets. They're basically an instruction to the court of how you want things to be handled and how you want your estate divided up. So this creates a couple of problems, though, when people are operating on that assumption. The first is that it doesn't do what they think it does, right? If they think it's going to control or help them avoid probate, it's not. It's going through probate. The other side of that, though, is when people have wills, but then they have all of their assets beneficiary designated, which when you have a payable on death or a transfer on death designation, those avoid probate. They just pay directly to the beneficiary or transfer to the beneficiary on that form. That creates a lot of issues, though, when your will has very specific plans in it. So the two biggest issues that come up with that is if you have expenses of the estate, but all the beneficiaries already have their money, there's no guarantee that that personal representative has the ability to pay those expenses. Maybe they aren't one of the beneficiaries, so they don't have those funds available to themselves, and they're not guaranteed to get it back from the beneficiaries, right? So that can be a big concern. The other concern, though, is that one of the beneficiaries is also the personal representative. Well, even if they have their share of the estate already, if they're using their share to pay those expenses, there's no guarantee that they'll be reimbursed. So if everybody wanted to get their equal share, like if everybody was 1/4 beneficiaries, well, if one of those 4 people uses more of their share to pay expenses and there's nothing left to reimburse them, then they didn't actually get the percentage that was originally intended. So making sure that if you're using a will, that you know that you are intending to use probate, that's what, you know, it's going to appear like to everybody that you're intending to use probate, but also making sure that there is at least something in the probate estate to help pay expenses, so that you're making sure that they have access to those funds. I guess one last kind of problem that I see come up a lot with people who are using wills is somebody at the bank, very well intentioned, but unfortunately incorrect in this matter, will tell them, oh, you should just put the person who's in charge of the estate, the executor or personal representative, put them on the account so that it just goes to them and they can pay bills right away, or make sure they're the beneficiary of that so that they can pay bills right away. You know, so that nothing gets frozen, it's not going through probate, right? And that sounds great in theory until you realize that when someone's a beneficiary on an account or a co-owner, joint owner on an account, Once the other owner passes away, or once that person passes away and it transitions to the new beneficiary, it's that person's money now. They don't have to share it with the other beneficiaries. They don't have to spend it on the estate, right? They're under no obligation to use that money, which is now legally theirs for the purposes that were originally intended. So if you're using a will and you want what you have in the will to actually happen, you need to use some level of probate to accomplish that. You can't, it doesn't mean all of your assets necessarily have to go through probate, but you want to make sure that there is enough in the probate estate to pay expenses, to cover any remaining mortgage, to make sure that things actually happen according to the way you want. And in particular, where this becomes a big issue is when someone has provisions in their wills, let's say like a trust for a minor, or some child who has a child with special needs and they need a supplemental needs trust. They may have all of those things set up by their will, but if all of the money avoids probate and goes directly to those people, none of the protection of those trusts comes into play. So you really need to make sure that if you're using a will, that you work with somebody who can help you make sure that your intent actually comes to fruition, that you're actually using the document properly. So know that wills do go through probate. They do not help you avoid probate. So that actually kind of goes into one of the other myths on the sheet that you'll see, where it says estates can avoid probate with a pour over will. What a pour over will is, for those who are unfamiliar, is a lot of times when someone has a trust, or when someone has a trust, I'll say, they also have what's called a pour over will. What that will does is it says, if something goes through probate, put it back into the trust. So it's kind of like, I think of it as like a pitcher, right? You're pouring it back into the trust. But thinking that the pour over will help you avoid probate is incorrect. And unfortunately, I've seen attorneys actually say that, and it's incorrect. If you have a pour over will, it will not help you avoid probate. It will still use probate. That's how wills are used. So that's unfortunately a common myth, and there are unfortunately attorneys out there who will say that as well, and it's just wrong. With avoiding probate, if a probate avoidance is the goal, that's where people will try to use beneficiary designations a lot. That's a very common thing that people try to do. And I think a really important myth to bust about that is beneficiary designations, they do help you avoid probate. They transition those assets outside of the probate estate. The problem is the myth is that that's a good plan. And they are not. Beneficiary designations are not a plan. They're tools to use as part of a plan, and we often do. We often use them in coordination with a trust, for example, or in coordination with someone's will, different provisions in a will. But to only use beneficiary designations and not have a will or not have a trust is not a good plan, because beneficiary designations do not account for the unforeseen circumstances that can come up in someone's life. If one of those beneficiaries is in the middle of care, or like long-term care when they inherit, or if they have a substance abuse issue, or if they pass away, is it going to the people you want it to go to? Those beneficiary designations by themselves cannot account for that. They're not meant to. They were never meant to. They are specifically designed to transition the account from one person to another. That's all they're meant to do. So if you have provisions in a plan that, in any good will or any good trust, there will be provisions in there that say, if anybody inheriting from me has these sorts of issues that come up in their life, here's what happens. They're protected from that happening. So this kind of plays into our topic next week a little bit too. So I won't touch too much on that, but just know that it can help you protect the people that you love and make sure that you're not leaving things to somebody in a way that is going to cause them harm. Beneficiary designations by themselves do not do that. If you leave it to that person, it's not helpful. It also doesn't help the person handling the estate actually pay expenses, right? You need to make sure that in their role as a trustee of a trust or as a personal representative in a will, that they actually have funds available to do that. If they don't have funds available to do that, then they're relying on the outside funds, which may or may not help them. Okay, so another really, I guess one thing to keep in mind too, and just I'll talk about it very briefly because it sort of plays into what I just mentioned, but with children with special needs, a very unfortunate myth I think that people run into is that they've been told, or they think that, well, okay, they are only allowed to have so much sometimes on some of their programs that they're receiving assistance through, right? Whether that's some sort of Medicaid or it's some other form of means tested assistance, oftentimes those children are only allowed to have so much. So the myth out there that people think they need to do is to disinherit them, to not leave them anything, because leaving them something would cause them harm if it was left to them directly. And the myth is that you have to just disinherit them and you can't leave them anything. You can't help them going forward. And that thankfully is not the case. This is one of my favorite myths to bust, because you can help those people still. You can leave them inheritance that will help supplement their needs. And that's where what's sometimes called a special needs trust or a supplemental needs trust is very helpful and very important to use for those types of people. And that could be something like I was mentioning a second ago, where it's a provision in the will or the trust that triggers if that's necessary, or something you preemptively set up knowing it will be something you need for that child. And this doesn't just have to be for children with special needs. It can be people with other later in life disabilities, or like health concerns where they have high medical costs. I mean, there can be a lot of reasons that these types of trusts need to be set up. So you do not have to disinherit these people to prevent any harm coming to them. You can still help them if that's what you want to do. So the one last thing I'll talk about beneficiary designations, because this does, again, very much so tie into this, is when we're talking about funding an estate plan, what we're talking about is making sure the assets that you have actually follow the estate plan. So if you have a will, that means we're intentionally sending some things through probate so that the will actually does something. If you're using a trust and your goal is to avoid probate, that means sometimes, depending on the type of trust that you're using, titling certain assets in the name of the trust, or beneficiary designating things to that trust so that the trust actually controls those assets. So just like a will only directs probate assets, a trust only directs the assets that it actually controls or owns after you've passed away. So funding the estate plan is making sure that that actually happens, retitling things if need be, updating beneficiaries if that's what the way it needs to be done for a certain asset. And it's really, it's critical that you actually do that, because if you don't, you have a very fancy document that you paid a lot of money for that is not directing things. If you have a will and you have everything avoid probate, what good is that will doing you? If you have a trust, but you don't have that trust actually own anything, it's not helping you either. So if you're going to set up your estate plan, or if you already have one, it's critical that you know how that's actually going to work, or that you find someone who can help you figure that out. It's not something I would expect everybody to be aware of, right? It's why it's one of the most common myths we run into, is that you don't really have to. It's not really necessary. No, it's absolutely necessary. So with trusts in particular, a big myth is that they're only for wealthy people, right? Or if it's only for people over an estate of a certain size. And that's not really the case. It's really not the case at all, honestly. Trusts are meant for the big goal of like a revocable trust, for example, where you hear a lot of people talk about those, or a living trust. The big goal there is to avoid probate, but still have a plan like a will provides. A trust it has all of the same protections for beneficiaries that a will should have. It still has all of the expenses paid by the trust first before the beneficiaries receive anything. It has special terms for those beneficiaries. It makes sure that the split happens the way you want them to, but it's not subject to probate. So if you want the protections or planning that a will provides, but you also want to avoid probate, that's where a trust is probably the better option. And it doesn't really matter if you have $100 million or $100,000. If your goal is to avoid probate, and you have some type of planning that you need done for beneficiaries and all of that, a trust is the way to go for that. And now there can be exceptions to that, absolutely, right? There are times where if, for example, if someone's estate size is under a certain amount, you don't even need to go through probate. So if your total estate size is under $50,000, and I don't just mean each individual asset, I mean literally the whole estate, that would otherwise go through probate. If it's under $50,000, you can just transfer that by what's called transfer by affidavit, which doesn't come up too often, but that is one reason why someone wouldn't need to go through probate. But if if that's not the concern, if it's more of, I just don't want to go through probate, but I also want a plan in place, that's where a trust is very helpful and really the only other way to go. But there are many, many kinds of trusts. You can use them for a lot of different purposes. So I mentioned $100 million. That may have been a bad number to use, because if you're that high in net worth, you're going to have a whole different type of trust than somebody who does have 100,000, right? I mean, then we're talking about estate taxes at that point. Moving on from that, though, with trusts, another unfortunate misconception is that if you have a revocable trust, if you put your assets in a revocable trust, it'll protect your assets from long-term care expenses. And I think where this myth tends to come from is a lot of times certain types of trusts can be used to help protect from long-term care expenses or from having to spend through everything. And it used to be, prior to 2014, August of 2014, revocable trusts couldn't be recovered against by long-term care expenses. What I mean by that is Medicaid in Wisconsin has a program called estate recovery, where just like any other creditor, they say, we paid this much for your care. Now we can recover against what you did keep. So that used to be the case if a trust was created prior to 2014 or August of 2014, but that's no longer the case even on that front. They were always still available for your care, though, because if you had $100 million again in that revocable trust, you still weren't going to qualify for Medicaid. So they do not protect, revocable trusts do not protect against long-term care expenses or estate recovery if they're created after that date, after the date of August 2014. So that's where the next myth comes up a lot, is that transferring all of your assets to your kids or gifting to the kids is the best way to protect against long-term care expenses, right? Where this comes up, and unfortunately, again, this is an area where there's a lot of attorneys out there who would probably recommend the strategy where, just gift the home to your kids, put the home in the kid's name, and think that that's a good strategy to protect against long-term care expenses. So with Medicaid, they look back 5 years from the date of application to see if you made any sort of transfer like that, or if you gifted things away. And so in theory, you could gift the home to the kids and make it out 10 years, and it wouldn't be a problem for Medicaid. That part's true. But why it's a myth, or why I would consider it a myth that it's a good idea, is that when you transfer the home to the kids, there's better ways to plan around that for a couple different reasons. One, if you've ever heard of that step up in basis, it may have been talked about a lot on the news lately. What a step up in basis means is your cost basis in your home is essentially what you paid for it. I mean, that's a very simplified explanation, but just think of it that way. When you pass away, the IRS says if it's part of your estate, it gets adjusted to fair market value. And then when the kids sell it, they don't have to pay capital gains tax on that sale, because unless that it grew even further after that point, but it'll lessen or eliminate those capital gains taxes because they don't technically have a gain according to the IRS. If you gift property over to somebody with a cost basis, it doesn't get that step up in basis on your death, because it's only if it's part of your estate that it gets that cost basis adjustment. So if you no longer have it, it doesn't get that adjustment, right? So when you gift it, the IRS says it's whatever you currently had gets gifted to that person, meaning they will very likely have a capital gains problem at some point. So it's not good planning for tax purposes, especially. But where it's also bad planning is whatever happens to the owner of a property also happens to that property. So one of the biggest issues that we run into with that would be, well, okay, you're trying to protect it from your care, right? You don't want your home eaten up by long-term care expenses. But you also have certain protections for your home in the fact that, if you filed for bankruptcy, or if you were sued for some reason, there's homestead protection for the person being sued. The law doesn't want people to be homeless if they can avoid it. They want to protect that to a certain extent. So if it's your primary residence, you have some protections from that, even though it may not be protected from long-term care expenses. If you gift the property to kids, to other people, even, it doesn't have to just be kids. If they don't live in that home, which is often the case, if they don't live there, they don't have the same exceptions to those problems like you would. If they file for bankruptcy and they have their own home, that just looks like a second property to the court, so that it is recoverable if Somebody is getting sued and they have a vacation property, which in this case, the home that you've transferred to them would look like, or it would just look like a second property. It could potentially be subject to those things. It might be subject to their divorce, a division on divorce. It can also be subject to their own estate plan. And this can be a big issue when, you may have wanted the kids to inherit it eventually, but you then, if one of them passes away, if one of their beneficiaries has one of those issues, like a substance abuse problem, creditor issue, other lawsuit liability, whatever it is, the home is suddenly subject to that too. And that can be a really big problem. So a better way to deal with transferring assets to protect against long-term care expenses, if you're trying to plan in advance in particular, is looking into an irrevocable trust. I mentioned revocable trusts are not protected from care costs, but as long as the irrevocable trust is set up properly, it can be protected from your long-term care expenses. So that would be the way I would recommend someone go over just gifting to the kids, because there's just there's a lot fewer protections for if something goes wrong in the meantime, let's put it that way. Going on into other sort of Medicaid planning myths, one of the most common questions I get is, I thought there was a certain amount of money you could gift every year that, the IRS says you can gift. On the sheet, actually, this is something we need to update, I guess, because it says $15,000 per person per year is what the IRS says you can do without filing a gift tax return. It's actually $16,000 a year now. It went up this year. That is for the IRS and gift tax purposes only, and it's tied to your estate tax exemption if you go over. So if I gave more than that amount, I would have to file a gift tax return, and that would lower my end of life exemption by the amount I went over. That's usually not a problem for most people because they have your exemption is $12.06 million. So unless you give more than that, not a big concern. But unless you already have a taxable estate, then it definitely is a concern. But that rule does not apply to Medicaid planning. So the Medicaid says you can give $0 away without it being a potential divestment. So don't think that you're getting around Medicaid's rules by following the IRS's gift tax exemption. They do not play nicely together, and it will not work. And just a reminder too, if anybody has questions, remember that there is a Q&A function that you can send in and I'll see them come up. So if anybody has questions, please feel free to do that. Okay, so yeah, don't gift though without thinking about the consequences. I know, unfortunately, a lot of people think they're getting around Medicaid's rules and saying, well, I was within that amount every year. Why is this an issue? Well, unfortunately, Medicaid doesn't care. Their rules are not set up for that. It's just a different agency's rules, right? That's why it doesn't apply. So just be very careful with that. Okay, so with long-term care expenses, there's pre-planning you can do, but just make sure that you're talking to an elder law attorney in particular before you, or someone who practices in elder law, before you engage in any planning to think you're getting around long-term care expenses or think you're protecting things when you may not be, and make sure you're doing it the right way for you. Don't just do it because that's what someone told you to do or that's what a lot of people are doing. There's a lot of things you need to be aware of that you just, if you're not doing this for a living, you're not going to stay on top of it, nor should you have to. Okay, so I guess one of the last kind of myths here is that if you have life insurance proceeds, and this is probably going to be less of a problem for most people, but if you have life insurance proceeds that they're not subject to estate taxes is the big myth. They are not subject to income tax for the recipient most times. So if I inherit a life insurance policy from my parents, or if it pays out to me, I won't have to pay income tax on that. However, life insurance is part of someone's taxable estate still. So this would really, again, this is not going to be a problem for most of you guys. I'm sure it's not a problem for me. I wish it were. But if you have a life insurance policy, if you had let's say somebody had a $13 million life insurance policy, that's over the taxable estate exemption of 12.06, right? If that pays out, if that's part of their estate when they pass away, it is subject to estate taxes, the amount over that 12.06. So I used 13 very intentionally there. But yeah, so again, not a problem for most people, but just know that it's not something that will avoid estate taxes if that is an issue for your family. If you are looking to avoid estate taxes, there's other ways to plan around that. But again, it's very involved planning. You want to make sure you're talking with someone who knows how to help you avoid it, or has dealt with it before. Okay, so I'm kind of I'm a little over actually. So I don't see any questions, but if just as a reminder, the forms you'll get from us are the like our estate planning myths that I mentioned that I've kind of been going through a little bit with you, and then also that feedback form. That feedback form is where you would let us know that you'd like us to reach out and set up a time to talk with you. Remember, they're complimentary initial consultations, so you're not going to pay to have that consultation. And we usually set them up for about 2 hours. We do ask for a lot of information for those, so just be prepared if you are coming in to talk to us that there's a lot that we ask, but we ask it for a reason. It's very important to know all of those things, including people involved in your family and the types of assets that somebody might have. And then again, next week, our topic is learning about, protecting family from things that can happen to them, protecting what you're leaving them from those sorts of things happening, and also protecting them from potentially themselves if that's a concern. So I hope to see you guys next week and enjoy.